This is Centerville Mobile Home Park versus Craig Klopfenstein and Gretchen Anderson. Mr. Daniel Landman is here for the plaintiff. One of the owners of the park, Christy Senzo, is here, and Meg Bauer is here from Legal Aid. Both Mr. Klopfenstein and Ms. Anderson are on the lease, but I think, does she reside there or she's just on the lease?
She's just on the lease as a co-signer.
All right.
She's actually over in Orchards Rehab over in 3 Rivers. She spent 2 months up at Borges and she's over at rehab now.
All right. Well, this is filed as a termination of tenancy action. We were here previously on March 16th. They allege a number of matters: disturbing the neighbors, cats, overall appearance of the unit, loud music, other things, and they wish the defendant to move. And that matter was filed. Meg Bauer filed an appearance on behalf of the defendants. What I set this for today for 45 minutes, thinking that's going to take us a while, but we're probably going to have to set a trial on this, I would imagine. Mr. Landman, let me start with you. What do you know about the current status?
Your Honor, here's what I can tell you. I think the court is absolutely correct as far as the need to schedule a trial date. While I have not received any kind of formal answer from Ms. Bauer, she did verbally deny the allegations last week, or at least indicated that she did not believe, based on her review of the matter, that there was a sufficient ground for termination. We obviously disagree. Since last week, it is my understanding that Ms. Bauer served a FOIA request on the Constantine Police Department. We became aware of it because the Constantine Police Department turned around and reached out to my client, trying to get some information that Ms. Bauer had requested in the FOIA request that the Constantine Police did not possess. And to the best of my knowledge, we cooperated with the police's request. I don't know if they have made any type of disclosure to Ms. Bauer. I did not get a copy of either the FOIA request or any response thereto. I believe also that Mr. Klopfenstein has since this matter was first heard a week ago or right before the hearing, maybe the weekend before, he has taken down the shelter that he had created and built essentially to allow feral cats to stay warm. And I think that has now been disassembled. Other than that, I know of no difference in the current condition or state of affairs of the home site. The very, very bright light that shines, the floodlight almost, that shines in neighbors' homes, which has caused distress to neighbors, we believe is still there. He may at this point have stopped playing the loud music, perhaps as late as he had been previously. Again, that resulted in complaints from neighbors. I don't know whether he has removed the multiple bowls of cat food that was on his porch to feed the feral cats. That may or may not still be there. But again, I think we would take the position that these are items that the statute does not permit to be cured anyway, and that as of the date of the 30-day notice, the question is, what was the state of affairs for the home and the home site? And we believe there's sufficient grounds for termination based on the condition at that time.
Just as a matter of context, Centerville is one village in St. Joseph County. Constantine is another. They're both quite lovely little small Michigan towns. The police departments are combined in a very interesting attempt at cooperation. Centerville and Constantine have merged the 2 police departments under one chief. He's a retired state police officer and he's doing an excellent job. So they have the ability to share officers between both towns, use the tax base to support the department, and it's really worked quite well. So the Constantine Police Department is also the Centerville Police Department, and this complex is located in Centerville. Ms. Bauer, what's your position?
Thank you, Your Honor. First, we have an issue with the notice in this case. The notice is addressed by first-class mail to 59 Thomas Court, but none of the tenants in this park receive first-class mail at their street address. The tenants are required to get a P.O. box, and any mail directed to 59 Thomas Court would be returned as undeliverable, which we actually have some evidence to support or to demonstrate. So from a practical matter, Mr. Klopfenstein didn't actually know that this termination was attempted until he received the summons and complaint. From a contextual matter, the termination notice says bright flashing lights, which is very different from what Mr. Landman just characterized to the court. We don't have Mr. Klopfenstein does not have any bright flashing lights and didn't understand until just now what he was being accused of with regard to that allegation. We don't have a list of any neighbors that have been disturbed by these allegations, so we certainly would ask for a list of witnesses and exhibits. The only lease violations that Mr. Klopfenstein has received predate the previous case. Your Honor may recall that there was a non-payment of rent case that brought the parties before the court and fairly recently, all stemming out of the park's policy of having $175 in late fees and refusing to allow anything but exact payments through their online portal payment system. We believe that this case is being brought in retaliation for Mr. Klopfenstein having defended and largely prevailed in that matter. Because again, he has not received any lease violations prior or subsequent to that date, but also he doesn't have any lease violations about his lights. He has a small radio that he listens to, but he has never been told that his radio is too loud. He doesn't have any knowledge or record of that. Also, it's a pretty small radio, so sure we might have an evidentiary issue on that. Mr. Klopfenstein has requested about over a year ago an accommodation to allow one of his ESA, his emotional support animal cats, to be an indoor-outdoor cat. That cat is fixed, has been fixed the entire time. They've known about it for over a year, and he doesn't seek out or rehome other tenants' stray cats or outdoor cats. And then he denies
Well,
that
you haven't filed an answer. You're testifying. So this is about the fifth time that I've been with Mr. Klopfenstein where the neighbors complain about him and feral cats. When I first heard he was living there, I asked if there were cats. He is a cat lover extraordinaire. He's used the emotional animal defense in the past. And in several previous tenancies, the landlord and the other tenants were aggrieved by his attraction of feral cats. I'm not sure what this structure was about, or a guy ought to be able to play a radio in his own trailer, but I'm not sure what the light is. I'm not sure what this other stuff is. This is why we need a hearing. And
Judge.
Yes.
Summary proceedings rules authorize an oral answer, but I have a largely prepared written answer that I will file with the court. But we have not been...
I accepted that at your first appearance, but I guess you're essentially stating his position. And I don't know if there's one cat or 112, what the circumstance is. I don't know about the bright light. I don't know about the noise. Um,
So for that reason, Judge, we'd ask that's part of why I've asked for a witness, maybe perhaps a court deadline for witness list and exhibit list filings. And the last thing I was going to say a second ago is that we have not received a timeline on our request from the Constantine Centerville Police Department, which was not a subpoena. It was just a Freedom of Information Act request. So we have no obligation to disclose that to the other side. But we'd ask for a little bit of time here because I don't know how long it will take the department to process that request. We have paid for it. So,
all right. We did struggle, and he had some legitimate defenses in there. Some of the things that the park was doing, the way you had to pay your bill and the very high late fees and some other things, we had to work through all that. And it was a payment of rent case, and he always was willing to pay his rent. He just didn't agree with the amount. So I'm going to need an escrow order here. I don't want to get him sideways on his rent. What is current rent?
I don't have the figures from the last case in front of me.
The
I'll
manager,
have to defer.
Yeshua, was here with us last time. She's not. What do you know what the current rent is, Mr. Senzo?
Yes, Your Honor. Let me just verify before I misspeak.
And Judge, while Ms. DeCenzo is pulling that information and I'm trying to pull up my records, I'll indicate that this is a situation where there's a lot rent and then a home purchase agreement that is paid. So we have a couple of different figures here.
And let me ask this, are you representing, I don't think I got an extra. Here's the
No.
appearance.
Ms.
Are
Anderson,
you representing just Mr. Klopfenstein? You're not representing Gretchen
Correct.
Anderson?
Correct, Your Honor. Ms. Anderson does not live at the property. They've not filed a supplemental complaint. And I've never spoken with her. So, no.
All right.
She is a signator on the lease, Your Honor.
Yes. Well, theoretically, she's subject to default on a termination of tenancy so that she couldn't live there if she wanted to, but I think we don't really need that. I don't, at least not at this point. But I do need to know what the rent is and then what the payment is.
Do you want the breakdown or just the total amount, Your Honor?
Give me the breakdown.
Okay, so his home purchase payment is $95. Lot rent is $440. And then there are additional fees at $21.50.
What are those other fees? Water fee and that sort of thing?
So no, the water is a separate charge and it's based on consumption. I would say on average, he's around $42 to $43 for water.
And does he pay that to the park or he pays that to?
Yes, sir, to the park.
All right, $42 for water. What's the $21.50?
So $8.50 is for the meter, the metering system to read consumption. Then we have our administrative fee for $5, a mobile home tax fee for $3, and a maintenance fee at $5.
All right. Let's add all that up. 95 plus 440 plus 2150 plus $42 estimate for water gives us $598.50.
Yes, sir.
I'm gonna just round it up to $600. He doesn't want to get sideways on the rent either. He doesn't want to get to the end of this hearing and find out he owes 5 months of rent. And we got other problems. He budgeted for this. So do an escrow order for $600 starting in March. Because this is going to take a while. Plaintiff's got to file a witness and exhibit list. This is the equivalent of a criminal case asking for a more definite statement of the charge. The original complaint print is so small I can't read it. Has been on specifically you and your occupants' conduct with the community have been unacceptable, but including but not limited to causing excessive noise, having radio playing at all hours of the day and night, bright flashing lights. Additionally, you have failed to maintain your home and home site in accordance with community rules and regulations, including but not limited to failure to remove and properly store outdoor items on your home site, failure to remove debris and bulk items from your yard, failure to remove improperly stored trailer, failure to remove exposed exterior cords, failure to remove bowls of animal food on porch, failure to remove heat lamps, failure to remove animal enclosure, and failure to maintain the general appearance of your home and home site. Furthermore, you've been housing and feeding stray animals, which poses a health and safety risk to
yourself and the community is what it says that I can read.
That's what's on the 30-day notice.
all right. Oh, yeah, that's on the 30-day notice. I'm looking at the actual complaint. So we're in the ballpark. It's maintenance of the property, a bright light, loud noise, bowls of food outside, structures, housing and feeding stray animals. Mr. Landman, how long will it take you to file a witness and exhibit list?
I would certainly think, Your Honor, that we would need no more than 2 weeks.
April is a tough month. I have a vacation. Judge Patterson has a vacation. Meg's already taken her vacation.
Well, I'm actually taking one in May.
And I'll be out April 1st through 3rd.
All right, well, let's see what we got here. I also am really backed up on my jury trials, criminal jury trials. I've been stealing criminal jury dates for some of these landlord tenant cases. So 14 days and 14 days gets us to
April 6th, Your Honor, but I think as I said, I'll be going.
no, I have April 29th at 1 o'clock.
And Judge, that escrow order, you said starting in March, but
So he'll owe March and April's rent.
he's already paid March to the park.
All right, then that's not an issue. When was the notice to quit?
Actually in December, Your Honor.
February, December. Yeah.
So they're accepting rent after the notice to quit?
Under MCLA 600.5779, Your Honor, they're entitled to and he's required to pay it.
In spite of the Park Forest case?
It's statutory. I can read it into the record. 600.5779 provides as follows.
And I believe my colleague is correct, Judge.
Is this in a mobile home case or in any context?
No, just a mobile
No,
home.
manufactured home.
Okay,
It reads, in every action to terminate a tenancy in a mobile home park for just cause.
I got you. The
Tenant
rules
shall
are different
continue
for
to pay
mobile and
all rent and
manufactured
charges.
homes. So I don't even really need an escrow order. He's already paying his rent. And as I said, he doesn't want to get behind. I won't need the escrow order. Statute requires he pays the rent. Miss Anderson is listed as a tenant. If she doesn't appear, she'll simply be defaulted at some point, and it may be meaningless to her because she doesn't really want to live there anyway. But if we get into a hearing where there's issues regarding money damages, we're not there at this point. This is just a termination case. All right, let me repeat. Plaintiff has 2 weeks to file witness and exhibit list. Defendant has 2 weeks from receipt of that.
Oh, excuse me, Your Honor. And Your Honor, if I may, if I could ask to have until April 8th instead of the 6th, simply because I'm going to be gone from the 1st to the 3rd.
That's fine.
All right, and then that would give Ms. Bauer till the 22nd.
I will set the trial. The problem is we always get into the weeds on these things. I'm setting out 4 hours. I don't have lots of just blank days with nothing to do. I would hope we could accomplish this in 4 hours, but we'll never know until we try. So I blocked out 1 o'clock on April 29th. Mr. Klopfenstein, I'm not ordering an escrow order that you pay your rent. You'll pay it anyway. If you don't pay it, then they can ask me for an escrow order and I'll hold it, but I trust you're just going to continue to pay it. And we're only talking about 1 month. So we're going to have a trial.
There was a jury demand, and there isn't in this case.
No, there's no jury demand. My only reluctance is knowing how these things go, whether 4 hours is probably get through 1 witness in 4 hours. But I don't have the luxury of taking 3 or 4 days to do this. So we'll start with 4 hours on April 29th and see where we could go. I don't think this is going anywhere but trial. I don't think he wishes to move. I don't think they wish to have him there. All right. Mr. Klopfenstein, do you have any questions?
No, sir, Your Honor.
All right, you stay in contact with your attorney. That's not a problem. As you know, from time to time, I walk through the park over there. I go everywhere. I drive through other parks. I drive around, try to see what's going on. So I'm familiar with the situation, but I haven't been in this park probably since last fall. But I'm not going to go over there and look for problems. I know the lay of the land well enough.
I was actually.
All right. What's that?
I have been contemplating, and I'll file a motion to this effect if it's necessary, but I have contemplated whether it is appropriate for us to do a viewing in this case. Also, the bench trial on April 29th at 1 p.m., that is in person, correct?
Yes, it is.
Thank you, Judge, for clarifying.
Thank you, Meg, not Zoom. Well, then I won't go over there, less requested to for a viewing. All right, I'll see everybody on April 29th. I'll wait for your pleadings, and you're all good to go.
Thank you,
Thank
Judge.
you, Your Honor. Have a great afternoon.
All right, it's getting there.
Craig, you're all set. We'll be in touch later.
All right, you're good to go. Thank you. Mr. Senzo, we'll see you next time. Meg, I'll see you probably Friday.
Sounds good, Judge.